Hello guys, welcome to our channel Random Dictation. Subscribe our channel for more dictations on daily basis.
Yes, and start. Unfortunately, the High Court overlooked the settled law that the High Court will ordinarily not entertain a petition under Article 226 of the Constitution if an effective remedy is available to the aggrieved person, and that this rule applies with greater rigor in matters involving recovery of taxes, cess, fees, other types of public money, and the dues of banks and other financial institutions. Full stop. In our view, while dealing with the petitions involving challenge to the action taken for recovery of the public dues, etc., the High Court must keep in mind that the legislations enacted by Parliament and state legislatures for recovery of such dues are code unto themselves, inasmuch as they not only contain comprehensive procedure for recovery of the dues but also envisage constitution of quasi-judicial bodies for redressal of the grievance of any aggrieved person. Full stop. Therefore, in all such cases, High Court must insist that before availing remedy under Article 226 of the Constitution, a person must exhaust the remedies available under the relevant statute. Full stop. While expressing the aforesaid view, we are conscious that the powers conferred upon the High Court under Article 226 of the Constitution to issue to any person or authority, including in appropriate cases any government directions, orders, or writs, including the five prerogative writs for the enforcement of any of the rights conferred by Part 3 or for any other purpose, are very wide, and there is no express limitation on exercise of that power, but at the same time we cannot be oblivious of the rules of self-imposed restraint evolved by this court, which every high court is bound to keep in view while exercising power under Article 226 of the Constitution. Full stop. It is true that the rule of exhaustion of alternative remedy is a rule of discretion and not one of compulsion, but it is difficult to fathom any reason why the High Court should entertain a petition filed under Article 226 of the Constitution and pass interim order ignoring the fact that the petitioner can avail effective alternative remedy by filing application, appeal, revision, etc., and the particular legislation contains a detailed mechanism for redressal of his grievance. Full stop. Para. For the purpose of deciding this case, it is not necessary to consider whether SICA stands repealed by the enactment of 2004 or whether that repealing enactment stands enforced as noticed by the division bench of this court in Aluminium Industries Limited versus State of Kerala (start 2005 within bracket 1 KLT 889 bracket close full stop. Still further, it is also not necessary to consider the question whether it was at the stage of reference that the case was pending before BIFR and whether the third proviso to subsection within bracket 1 of section 15 of SICA would nullify the plea of the petitioner. Full stop. This is because proviso under consideration only enjoins that the reference shall abate. Full stop. whatever be the scope of the term reference and status of proceedings before BIFR, the case in hand can be decided without holding that the BIFR proceedings have abated full stop. This is because Section 35 of the Surface Act, a later enactment, categorically lays down that the provisions of that Act shall have effect notwithstanding anything inconsistent therewith contained in any other law for the time being in force or any instrument having effect by virtue of that law full stop. That provision overrides Section 22 of the SICA, which is a previous enactment having come into being in 1985 full stop. Therefore, notwithstanding the abatement provided by the third proviso to Section 15 within bracket 1 of SICA introduced by virtue of Section 41 read with the schedule to the Surface Act, the effect of Section 22 of SICA no more survives Section 35 of the Surface Act full stop para. In this context, learned counsel for the petitioner argued that SICA could be treated as a special enactment occupying a very peculiar field and in that sense could be treated as one which would not fall within the purview of Section 35 of the Surface Act full stop. The Surface Act is an enactment to regulate securitization and reconstruction of financial assets and enforcement of security interest and for matters connected therewith or incidental thereto full stop. The SICA is an act to make special provisions with a view to securing the timely detection of sick and potentially sick companies owing industrial undertakings with the ultimate goal of taking preventive, ameliorative, remedial or other measures and the expeditious enforcement of the measures so determined full stop. Both enactments essentially focus on the measures which are needed for asset management either of the company or of the security company. Over.